Looks like we're live.
What's that?
It says meeting is now streaming live.
Yeah, but it's not, restream is, oh, okay. Yeah, we're good. It looks like we're finally live. Okay, so in that case, I guess we'll just roll with it from here. All right, guys, for all of you guys joining us today, good morning, good evening, good afternoon, wherever you are in the world. I know I have a lot of followers all over the world. Today, I'm joined with Matt Fakhoury, former prosecutor for Cook County and turned defense attorney, criminal defense attorney for Cook County. And today we'll be discussing the issues, well, not so much the issues, but we will be discussing the 4 officers charged in connection of George Floyd's death in Minneapolis. And we're going to get some legal perspective from Matt, being both on the prosecutorial side of things and the defense side of things. Matt, would you like to introduce yourself?
Sure, Greg. Thanks, first of all, for having me. I feel honored to be here. Yes, I am a former Cook County prosecutor, and then I did turn criminal defense attorney, as they say. My practice is here in the Chicagoland area. I also am a former professor adjunct professor, I should say, at DePaul University, where I taught some law courses in the undergraduate sociology department. Happy to be here.
Well, thanks for being here as well. To start, we're going to address the initial charges, mainly towards Officer Chauvin, who is the man convicted of killing, well, not convicted, but charged with the murder of George Floyd. And initial charges, which I believe he was charged on June 5th and taken into custody, which were third-degree murder and manslaughter.
Correct. Yes, correct. So initially he was charged with third-degree murder, which, you know, all the laws in the states are kind of similar, but the nuances are slightly different and the terminology is slightly different. But from a general perspective, so everybody around the country can maybe understand this, third-degree murder in Minneapolis is basically what's commonly referred to as reckless homicide everywhere else. Okay, so that means that his actions were so reckless, okay, so in disregard for the life and safety of others, and a death resulted, that it's considered a homicide, right? So although he specifically maybe didn't have what we call an intentional or a knowing mental state, right? He had such a disregard for human life that it's still considered a homicide, and in this case, under Minnesota law, third-degree murder, which is, again, essentially what we call a reckless homicide, right? So in other words, he did something that was so dangerous that he should have foreseen or should have maybe expected a death could have occurred, okay? Right. So although his intent wasn't specifically necessarily to kill him, that's what third-degree murder, at least in Minneapolis, is. Now, manslaughter is even less of a liability, so to speak. The mental state is a little less. Your culpability level is lower under your mental state if you're talking from a specific, like a criminal law perspective, and obviously the sentence is less as well. So for manslaughter, what you're looking at is, in general, is that they were negligent, right? They had a duty, or this individual had a duty to act a certain way. He didn't, again, intentionally or even recklessly attempt to do what he did, but he breached that duty in one way or another, and then a death resulted, which is, again, still a homicide, but now it's a lower level homicide, which is, in this case, again, a manslaughter. A manslaughter under Minnesota law is punishable by 10 years, while third-degree murder or reckless homicide, as it's commonly referred to, is punishable under Minnesota law at 25 years as a max. Okay, so that's initially what they did. Now, you know, what prosecutors, from a prosecutorial standpoint, what you want to do is load up the charges, especially in the beginning, right? You want to front load the charges. And maybe when you get to trial, you might want to remove some of the charges so the jury doesn't let them off on, let's say, a lower level offense or felony. But what you want to do in the beginning is really leverage the case, okay, from a prosecutor standpoint, and charge him with whatever you can in the harshest penalties or crimes possible. Now, third degree murder and manslaughter obviously are not as punishable or as severe as what they eventually charge him with, which is second-degree murder.
Right. Now, as far as the increased charges, I'm on June 5th, when he was initially apprehended, based on the evidence that I've seen, and I'm sure pretty much the entire world has seen, sans, a few people that just refuse to see it. One person in particular, Sherry, you've met her. She refuses to watch the video. But as soon as the charges were announced and upgraded to second-degree murder, which I called on, I believe, June 5th. I just called it out. I said, this guy's guaranteed to be charged with second-degree murder based on the law that I looked, because I looked into the Minneapolis or Minnesota law. And could you explain second-degree murder?
Sure. So second-degree murder, at least in Minnesota, is interesting. It's a very powerful tool for prosecutors, and it's all over the nation and even federally with prosecutors. So what they're basically trying to convict them under is what we call the felony murder rule, okay? And that basically means that a death that's even unintentional, okay, will rise to the level of essentially an intentional death because the underlying offense or crime was so egregious that a death was foreseeable, okay? So an easy example, like your classic law school example, and people will relate to this is, let's say somebody causes an arson, they set fire to a home, right? So the intent was to set fire to a home, but because of how bad and how egregious that crime is, an arson is, how dangerous that offense is, they could have foreseen that somebody was still sleeping in that home, and then a death resulted. So although that person could say, hey, I didn't intend for that person to die because of the arson, well, hey, that crime is so egregious, so dangerous that it's foreseeable that somebody could die. So what second-degree murder is in Minnesota, the way they're charging him is under the felony murder rule. It's a very powerful tool for prosecutors. So basically, any crime, all right, under one of these enumerated crimes, which they're saying is an assault here, okay? Any type of crime that fits under that rule, felony murder, and again, here's assault. If a death occurs while committing that crime, which it did here, now the crime is not a third-degree murder. It's been elevated to a more culpable mental state, or as we say in law school, a mens rea, because your mental state, your intent has gone up because of the foreseeable death of this crime. Does that make sense? So it's basically a tool that prosecutors use to charge somebody with a death that they didn't intend to commit. So it's a very, very powerful tool, and this is a legal principle.
That's basically without premeditation.
So yeah, there's a couple different types of second-degree murder in Minnesota law, but yes, you don't need premeditation. So, a lot of people think premeditation is formulated like a week or two or a month before, where you're planning on committing a crime and you go to the store and you buy a gun and you buy rope and you buy, tape and whatnot. That's premeditation, but premeditation could happen within a few moments, technically, okay?
Exactly.
Now, I don't think, arguably, there was no premeditation for murder here, okay, is arguably what's going on. What's going on is he should have known, right? He should have known that his conduct based on the underlying offense, which is like an assault here or a battery, was so bad. And what he did for 9 minutes, essentially, right? He had his neck on his knee on his neck, right?
8 minutes and 46 seconds.
46 seconds, exactly. So the underlying offense was so bad and so egregious that he should have, even though it was unintentional, it was foreseen. And because of that, now we're elevating it to second-degree murder, right? So what a prosecutor is going to do, and this is interesting, right? And this is what lawyers and judges do all the time. We're going to take a given set of facts in any case, right? In my law firm, we get a given set of facts, every day. And then we try to see, did the prosecutors get this right? Are they fitting this correctly with the law, right? And as a prosecutor, that's what you do. Let's take these facts and let's see which law, or the highest law, the law that has the highest penalty, fits the best with this particular crime. And here you have second-degree murder under the felony murder rule. You have third-degree murder because it was so reckless. And then as a fallback, you have this manslaughter charge, okay? Tim, go ahead, I'm sorry.
I just have a quick question. Could they still fall back on third-degree murder? I mean, is that still charged on the table?
Oh, yeah, absolutely.
Okay, so he's now technically charged with second-degree murder, third-degree murder, and manslaughter.
Right. So the way you got to think about it is second-degree murder includes third-degree murder and includes manslaughter because of the lesser or lower mental states, right?
Right.
So it's what we call in the law a lesser included offense. So If you're convicted of second-degree murder, because that mental state is so much higher, it's more intentional, that you're obviously have already committed the lower offenses, right? So if you're negligent, that means you breached a duty. It's a lower level. If you're reckless, that means you're a little bit more guilty or culpable. But if you have an intentional mental state, which is essentially what the felony murder rule under second-degree murder is doing because of the underlying offense, you're already, including all those lesser included offenses, right? So I think what will happen is it's obviously at the very least manslaughter, but that's easy, right? So this is going to go from second degree, between second degree and third degree. I think both fit very well. Obviously, they're going to go for the second degree murder because it's a higher penalty of a maximum of 40 years. Unfortunately, the first degree murder doesn't fit. Okay, it's because of the premeditation that we talked about. So under Minnesota law, you have to have some type of premeditation. There are other forms of first degree murder, but that's the one that would kind of fit here. I think they're going to have a hard problem establishing that, which is why they didn't charge him with first degree murder.
Now, I have a question. If there were to be some new evidence to come forward, for instance, witnesses or anybody that could attribute to, for instance, these two, we already are familiar with the story of them working at this nightclub together for roughly 17 years or so. I find it hard to believe, of course, that they've never met. I mean, there's no chance that they never met working together for 17 years. But if people were to come forward and say, listen, they had, these disputes over the years, and, clearly this guy didn't like, referring to Officer Chauvin, really didn't like George Floyd, could that be perhaps used as admissible evidence to charge him and upgrade the charges to first degree murder? I don't know exactly.
So here's the thing. So I don't know. I heard that they worked together. I didn't see the 17-year thing, to be candid. Okay, but let's just say, for sake of argument, that he didn't like him or he knew him, and there was some type of, they crossed paths and they didn't like each other, right? Not liking somebody is not considered premeditation, right? Okay. Premeditation is taking active steps to plan a crime. Okay. So there's a lot of people I don't like, right? And even if I think about committing a crime in my head, it's not necessarily premeditation, right? Premeditation is taking some type of advanced action, okay, to commit a crime. Buying a gun, buying a knife, getting a room ready to have somebody kept in there for a kidnapping or a restraint. Those are all types of premeditation, right? Premeditation, like I said earlier, can be formulated quickly, right? You don't need a month or a week to do it. But, potentially could something come about where they say that he maybe planned this? Maybe, but I think it's a stretch. I think the video shows.
I agree. I think that would be a very difficult charge to stick with, and he would very well be acquitted of that. If that were to be the case. Very quick, we're gonna go ahead and move on from Officer Chauvin to Tao. This is the officer that stood in the street asking, civilians to step away as they were recording, despite the fact that they were, pleading with them that this guy is clearly, he's having a hard time breathing, just get him up. There's one particular scene. I'm sure you've seen the video.
Yes, unfortunately, yes. And then again, I think I was like the individual you mentioned. At first, I saw clips of it in photos, and from a personal perspective, not really a legal perspective, I kind of didn't want to see it because I knew that I wouldn't be able to unsee it.
Yeah, it was rough.
Right, and I knew that's what would happen, and it would be haunting. So I did see it, and I was disgusted. I was disturbed, especially the part where he called out to his dead mother. So yeah, it's disturbing. It's lasted with me. It's that's my personal, obviously, opinions on this. But yeah, what's interesting to me from a legal perspective is the case of these next three officers. That's what I find very intriguing about this.
Okay, well, there's one more thing I would like to add before we move on to Tao, because he would be the next in line for this discussion, was the fact that Officer Chauvin ordered him to get in the car. I don't know if you remember that part of the clip. He ordered him to just get in the car, and George Floyd was complying. He said, "I'll get in the car. I'll get in the car." but Officer Chauvin didn't even give him a chance to get up. And, he repeated himself several times to just comply, get in the car. And George Floyd said, I'll do it. I'll get in the car. But
Okay.
Officer Chauvin ignored that, despite that was his command, and he kept his knee on George Floyd's neck. So, yeah, I just wanted to throw that in there because I know that's going to be a big part of the case, clearly.
So, yeah, I mean, resisting arrest, if that's what you're kind of referring to, right? You can't really resist arrest. It's unlawful to resist an arrest, right? But at the same time, what went on here was way past an arrest for any type of theft or fraud or whatever it was, and past the resisting charge. This went way past that, right? So that's going to come up, but it's not, self-defense to any type of murder or homicide, to say this person was resisting arrest, right? They clearly weren't a threat at that point to any of the officers, including Chauvin.
Right. Okay. So let's move on to Officer Tao. Obviously, Officer Tao was the one who stood, blocking any civilian bystanders from intervening.
Right.
And there's been a lot of criticism against him. He's also a veteran of the force, from what I understand. I don't know how many years he served on the force. Chauvin, apparently 19 years. I'm not exact on the figure, but I believe it was something like 15, 16 years veteran of the force. Of course, they're all being charged with aiding and abetting.
Right.
As far as his defense, could you see any defense in that?
I can. I could see it on both sides. And this is what's very intriguing. So, first of all, aiding and abetting basically means you have to commit you have to knowingly, okay, that's your mental state, right? You have to know you're committing some type of act that is furthering the crime, right? You're assisting or furthering the crime in some way, and you have to know you're doing it. So arguably, as a defense attorney, okay, if I'm his defense attorney, I'm saying, hey, wait. This guy didn't know that a murder or a homicide of some type was being committed, all right? Now, what you have to remember is that his offense of aiding and abetting is punishable at the same level. It's the same offense as the underlying offense, which would be, let's say, second-degree murder, right? Or third-degree murder. So if Chauvin gets convicted, if he gets convicted and goes away for 40 years, potentially, okay, Mr. Tao could go away for aiding and abetting at the same exact level, at the same exact time, right? Because
so he could technically be convicted for 40 years.
It's punishable at the same exact offense as the same exact offense was. So it's like he committed the same offense, but in this instance, he's aiding and abetting it. So basically, he helped out, right? So as a defense attorney, my argument would be, hey, wait, he didn't know he was committing a homicide, okay? Maybe he knew he was committing some type of battery, or he should have known. Maybe his conduct was reckless. Maybe his conduct was negligent, which basically means assisting in a manslaughter, which I think this is more geared towards that. But did he know he was committing a second-degree murder? Did he know that, what was going on was reckless? I think it's more so, a third degree or a manslaughter for him, right? But here's the complication of it, okay? The complication is that you and I passing that day and these bystanders, they could have walked right by it and they wouldn't have been criminalized at all, right? We could have stepped over the situation hypothetically, right? Because we don't have a duty to act. But officers have a duty to act. They have a duty at a higher standard than we do, right? They have to act when they're off duty, when they see a crime, when somebody is in help, and especially when they're on duty in a situation like that. So arguably, Tao, not only did he assist by preventing other people from helping, right? But he had a duty himself to act and to stop, right? And in my opinion, the other two officers, that's where, their defense lies, right? They're newer officers. It's kind of a boys' club being in the police department. It's kind of a rougher atmosphere, is the truth. Him as a veteran of the force, right? And him as one of the leading officers there, right? Veteran officers there. He had a duty to act, right? So as a prosecutor, that's where I'm going with this, okay? Not only is he an officer, he has a duty to act as an officer in his situation. As a reasonable officer on the force for whatever it is, 10 or 15 years, you have a duty to act. And here's the funny thing about manslaughter, right? Manslaughter says that you're being negligent. You're not living up to a duty. You're breaching a duty that you should basically abide by, right? A reasonable duty. Now, ironically, the voice of reason in this entire incident was not only George Floyd, but it was those individuals recording it. There was one guy saying, hey man, why do you need to do that? Hey, you're hurting him. Hey, he's not breathing. Hey, I used to be in the academy. They didn't teach us to do that. You can't do that. You shouldn't do that. Get off of him. So now as a prosecutor, that witness is a perfect witness because he's saying everything that we're thinking and that should be thought as a reasonable officer or as a reasonable person would be thinking at the time. And if you're not, you have this guy saying it. You know what I mean?
Yeah, and the whole world's thinking the same thing as they watch that video.
Right.
Now, moving on to the other two officers who are both rookies. From what I understand, it was there was their fourth day on the beat, on the streets. Chauvin was their superior officer, their commanding officer. And these are the two officers, was it Adam Lane? Alexander Kwong and Thomas Lane.
Right.
Okay. Now, Thomas Lane was the one who was holding down George Floyd's feet, and Alexander Kwong was the one holding his body down while Chauvin had his neck to the knee. Mm-hmm. Now, both of these officers were on the fourth day on the job, on the streets, dealing with their superior requiring to call him sir, as it's been reported. And from what I understand, the one officer, Thomas Lane, actually told Chauvin, former officer Chauvin, that, we should turn him around. And Chauvin said, no, I want him exactly where I want him. This is completely verbatim, but, I want him on his stomach. This is where he's going to be. So in terms of the defense on these two particular officers, the other officer didn't attempt to intervene in any way from what I understand, but of course they're rookies. And given the 2016 policy that they instated, let me pull it up here. I already lost it. That's my fault. I'm sorry about that. But Minneapolis did, let me see if I can find it. In 2016, I'm just going to go off the top of my head. I believe it's the duty to intervene, which essentially means that by law within the city of Minneapolis, officers are required, and this is just a municipality law for all officers, that they have the duty to intervene if they see any officer misconduct. And he did attempt to intervene, but he didn't physically do anything. He didn't get off of George Floyd. He didn't, try to grab Officer Chauvin and say, listen, this is wrong. He's already handcuffed. I mean, he's in custody. I mean, they have him apprehended. What are the odds as far as them getting a fair trial, for one, in this case, for aiding and abetting, being that it's only their fourth day on the job, and one did technically try to intervene, but he didn't follow through with it. I mean, as soon as Chauvin gave him the order, this is where I want him, he stepped down and just continued doing what he was doing.
So there are many principles here that are very interesting. So first of all, I think these two guys are going to have a better shot at a not guilty verdict, and here's why, right? So Chauvin and Tao had a more direct or palpable role in this, and a jury is going to see this, right? They're going to feel and see the emotion and everything that was involved in that video. The other two officers weren't as directly attached to the horror of this video, right? So they were there, don't get me wrong. And as an officer, you always have a duty. And like I said, to a jury and to even your normal citizen, you hold an officer at a higher standard, right? So your duty to act and to help is at a higher level, right? But from a defense perspective, right, what you have to understand is, how did those two officers aid or abet or further the situation? when they have the superior officer who's obviously in control, right? You have a chain of command that you really can't breach, so to speak. And they did restrain him initially, don't get me wrong, as a part of the resisting or as part of, as part of affecting the arrest, right, the initial arrest. But as far as furthering a homicide, that one's going to be a harder conviction, in my opinion, to secure, okay? Because as a defense attorney, you're going to say, hey, listen, you want to send this guy away at the same level for the same amount of time as Chauvin on his 4th day of the job? You think his level and his experience and all that he should know is the same as Chauvin? And the answer is clearly no, right? Now, as an officer, you have a higher level, you should know more. But as a defense attorney, I'm going with this all day. He did not know he was furthering this crime. He was actually one of the officers, again, I'm not sure if it was Lane or the other one, said, hey, maybe we shouldn't do this. Let's flip him over.
That was Lane.
That was Lane, okay. And Lane, it was his 4th day on the job, as you said, 3rd or 4th day on the job. So to some degree, he did try to say, let's stop this. But this other superior officer said, no, I'm not going to do this. So in my opinion, the jury on that is, you said, are they going to have a fair trial? Well, you could apply that to any one of these 4 defendants, right? Where in the entire country are you going to get a fair trial? And
given the social media, or not just the social media coverage,
the media coverage, period.
The world coverage. I mean, this whole thing is spread across continents.
Absolutely, right. So, I mean, eventually they're gonna try this case, whether it's in somewhere in Minnesota, somewhere in Minneapolis, wherever it is, somewhere else in the country or in the jurisdiction, who knows? They're going to have to go to trial. And when they do, this is going to be a harder conviction, in my opinion, to secure, because I still think that it's going to be hard to generate a level of intent, a level of knowledge to further this crime that the prosecutors must establish as an element of aiding and abetting in front of a jury. Right. So Chauvin will be, to be honest, that'll be, in my opinion, pretty easy to secure. Tao will be a little bit more difficult, but with these guys, with the knowledge intent of it and taking all the other facts into consideration, that they're rookies and they have superior officers, one of them tried to do something, I think that's going to be a harder conviction to secure. Now, should they have done something? Maybe. I think if anything, they would get aiding and abetting on manslaughter, which again, like I stated earlier, is a lesser included offense.
Right.
So they might be convicted of a manslaughter charge, which is punishable by up to 10 years. I believe there is possibility of probation on that in Minnesota. So I still think that would be a difficult conviction as well. Okay, aiding and abetting on a manslaughter, which is a negligence charge, a criminal negligence charge. I think that would be difficult even in a situation like that for those 2 guys.
Yeah, especially when they're being told by the superior officer to comply with. Exactly. And I actually kind of feel for those officers. Obviously what they did wasn't right, but it's kind of comes down to that moral compass. Like, you got to put yourself in their shoes, and yes, they were in the wrong. They had the duty to intervene, but.
And that's what this is. You said what they did wasn't right, but that's the thing. They didn't do anything, right? But they're being criminalized for not doing anything.
Right.
And normally, again, if it was you or I, we wouldn't be criminalized for walking right past the situation, as cold as that could be. With them, that's where the prosecutors are going to have to hit this home to a jury. You have a duty to act, right? Imagine if that were you, Mr. Jury Foreman, or ladies and gentlemen of the jury. Imagine if that was your son or your daughter. Would you want this officer to act? And if he didn't, right, would you want that officer to face a judge or a jury? You would, right? So because they didn't act, that is criminal, okay?
Right.
To some degree, parents have a duty to act and protect their own children as minors, right? And we criminalize them when they don't, right? There are certain situations where we expect people to act and live up to a certain standard to help or to care for or protect other individuals. And if they don't, they're going to be held, by the state in criminal prosecution.
Well, thank you so much, Matt, for the interview.
No problem.
I know you said earlier you wanted to give your own take, your personal take on the case. If you'd like to, by all means, feel free.
Yeah, I've been doing like a lot of reading on this, and like I said, when I saw the video, it was disturbing. It really resonated with me for many ways. As a prosecutor, I enjoyed being a prosecutor. As a defense attorney, I see a different area of the law, but in no way, shape, or form can anybody watch this thing for 8 minutes and 46 seconds and not want to crawl out of their skin. And unfortunately, one of my favorite cases when I was in law school, and a case that I teach, is called Plessy versus Ferguson. And Justice Harlan, in his dissenting opinion at the time, said that the Constitution is colorblind, right? It doesn't see color, all right? And we expect our courts, we expect our judges, we expect our police officers, right, on the initial level to be legitimate, to be fair, to be race neutral. But what people forget, unfortunately, is that those prosecutors, judges, or police officers are human.
Exactly.
So they're seeing it from the perspective of a human biased eye, right?
Yeah, and every police officer, I'm not saying every police officer is the same.
Of course,
I'm saying every police officer is different. You will find officers with, prejudicial views and, these. Yeah, so, it makes this case very, very complicated.
Right. And, and just what I want to get at is, the human lens, when we view a situation through our eyes, our lens is naturally flawed, right? And we hope that a situation like this, when there is, discrimination or, some type of social unrest, is caught or it's addressed through the justice system properly. So if they don't get it on the police level, well, hopefully our prosecutors will make this right by upgrading the charges or doing whatever it is that needs to be done. And if something goes wrong in the criminal prosecution, we have the defense attorneys there, we have the judges there in case something slips through the cracks. So, our justice system, our police system is very flawed. In my opinion, it'll always be. But as long as you have checks and balances, and you have a court of appeals, and you have a Supreme Court, then hopefully, whether it's a state Supreme Court or United States Supreme Court, hopefully it'll be, any problems, any errors, any mistakes will be corrected, right? And unfortunately, sometimes it takes a while for that. That's my biggest criticism, that sometimes these issues take a while to be addressed.
Yeah, it's a very complicated judicial system.
It is, right? Too complicated.
So many levels.
So many levels, but it's a flawed one, and it needs to be constantly addressed and fixed, and hopefully bettered in one way or another. But thank you for having me. Sorry, I'm rambling.
Oh, absolutely. No, by all means. Matt, thank you so much for joining me and giving you your unbiased, objective take on these criminal charges brought against these officers. We'll see what happens. Obviously, this is going to be a very long-winded trial, and I'm sure the whole world's going to be watching. If you could, before we log off, just stick around. To everybody who's tuning in, thank you for tuning in, and hopefully you guys learned something about law. I know I did. I kind of studied up on it a little bit before going into this interview with Matt. So, Matt, thank you so much
Thanks for having me, Greg. I appreciate it. Thank you very much.
All right, guys, you're most welcome. All right, guys, take care wherever you are, and stay safe.